Welcome to the Information Management 360 podcast, brought to you by Archive 360, the industry experts in information management for the digital age. The Information Management 360 podcast delivers thoughtful conversations about compliance, records management, data security, e-discovery, and much more, so you can learn how to better manage and protect your data in the cloud. So let's get started.
Greetings. My name is Bill Tolson, and I'm the Vice President of Compliance and e-Discovery at Archive 360. Today's podcast is titled A Review of EU Privacy Regulations. And by EU, I mean the European Union. Joining me today is Tara Taubman-Bassirian, consultant and owner of DATARAINBOW, a GDPR and data protection consultancy with a background in French law. And Tara is located, I believe, in London. Tara, welcome, and thanks for joining me today to discuss what's been going on in the EU around data privacy and GDPR. Can you tell us a little bit about your company, DATARAINBOW?
Hello, Bill. First of all, thanks for inviting me to this chat. DATARAINBOW is a consultancy, as you've mentioned, on anything compliance, data protection, and anything IT law and what concerns compliance with the specific regulation on digital and internet.
Great. That sounds really fantastic. Actually, and I know you probably know a heck of a lot more of this than I do, and I'll bring it up later on. But the new development in the Privacy Shield potential replacement that just happened, I believe, last Friday, or at least that's when I read about it. But that's a really interesting thing. But we'll get into that. The biggest topic, or the most important topic most people know about in our industries, is around data privacy, is the GDPR in the EU, and the fact that it was the first kind of big all-encompassing privacy law that really took everybody, I think, at least took everybody a lot of people in the United States by surprise, because they weren't really following it. But it is a very detailed law around consumer data privacy, and I think part of the push of the GDPR is that the EU now considers PII, or personally identifiable information, and the data subject's control of it as a human right, which I think is great. It obviously causes questions and issues for companies who deal in that kind of data, but I think it's a great step. So one question, Tara, I hear a lot around the GDPR is how is the GDPR authority set up in the EU? Is there one central kind of federated authority, or does each country have a separate data protection kind of organization that works hand in hand with the GDPR?
That's a really good question. GDPR stands for General Regulation that was passed by all EU nations. Everyone talks about it suddenly. Well, actually, GDPR was not a major revolution. There was already a directive for existing GDPR. There is also the Charter of Human Rights that bears the principle of privacy as a fundamental right. There is the Convention 108 that's been going on around. But what made the GDPR become a big news in the press was the far bigger fines that were introduced. So suddenly everyone talks about it. The difference between the directive and the regulation is that directive needs national entry into each legislation, while the GDPR in principle, once it was voted, it's directly applicable into any EU national legislation. There are some exceptions to what I'm saying, but mainly everything was just directly applicable. And then one of the very important principles in the GDPR is the consistency mechanism, trying to harmonize the enforcement and application of GDPR. Every EU nation has its own data protection authority, or some people call it supervisory authority. They are, in principle, expected to enforce the regulation in a harmonized way. Fines should be consistent, and everything is overviewed by the European Data Protection Board, which is composed by a representative of each national data protection authority. So this is the way that the patchwork is spread. There are, again, exceptions into what I'm saying, because Germany, being a federation, they have more than one DPA, but they are represented by one person at the European data protection level.
Okay. That's really interesting, and I know a lot of people have wondered about that. You see references to the Irish, DPA, and the German or the Bavarian DPA, those kinds of things. So yeah, it kind of gave me a hint that countries have their own authorities as well, but the overriding kind of set of rules of the GDPR is what they all follow.
Yeah, the expectation was that everyone would apply and enforce GDPR at the same level with same principle. But of course, national legislation sometimes interfere with the regulation, and some data protection authorities haven't been that much active. You mentioned the Irish DPC. There's been a lot of questions around the lack of enforcement. The Austrian Data Protection Authority has actually been directly complaining that the Irish DPC is not enforcing. And funny enough, it's very important because this is where all the big corporations are based. They are tax intensive, but they are now kind of data protection intensive to be in Ireland.
Well, you sort of answered my next question, and it was around, I know when the GDPR first came into effect, the authorities were relatively hands-off for a period of time so that companies could figure out what was going on and how they should react, what kind of technology, what kind of processes they need to build, even though they had several years before that, they knew it was coming. But nowadays, in 2020, 2021, I've read stories both ways where the GDPR authorities have been more aggressive in their enforcement. But like you just said, that I've read the articles about complaints that they haven't been aggressive enough.
Yes, there are frustrations. As a consultant, I do find it sometimes difficult with what would I advise my clients, especially in the UK. I tell them don't do this and that, and then they come back to me and they say, well, all our competitors are doing it. So for me, it becomes an issue. I try to sell GDPR by showing the positive aspect on it. It's not only complying with the regulation, it's also what it brings to you as a matter of trust or also security. But it is true that when some data protection authorities do not enforce, it's kind of problematic. We've got some DPAs. The Spanish DPA is extremely active. They are one of their good clients are Vodafone. It's nearly once a month they get fined. Pretty small fines. In principle, the fines should be proportionate. They should be deterrent. Now, the other question is fining the best option? We've got a recent case where the Data Protection Authority actually asked the data unlawfully obtained to be deleted. I think that's worth more than fining. In UK, the main big fines were given to British Airways for data breach and to Marriott International for another data breach. The amount was lowered partly because of financial situation and the COVID that also makes it worse. Fining BA actually result on BA bringing up the price of the tickets. So somehow it's the BA clients that are double fined. First time they get their data breached, and second time they will pay more because obviously the company needs to compensate what the millions that we're going to pay for the fine. So I wrote an article. I've been discussing if fining the best thing. UK ICO Elizabeth Denham, it has changed now, it's John Edwards, but at the time she started the first annual meeting she organized, she said that she might make the directors personally liable. Might be a better intensive than simply a financial fine. We've got the statistic on who's been fined and for what amount. I've been asking about have they actually recovered the fines, and I haven't seen the result. That's the other point.
Yeah. Actually, that was a question. I had just read an article last week that said that 2021 was a record year for GDPR fines. I think it was somewhere over $1 billion just for that year. Have you heard that? And like your question you just brought up, are those fines actually being recovered, or are they just being fined and kind of they'll play with it in court for 10 years?
I don't have the answer. Some DPA, I think the Spanish is the case, they use the money themselves. That's not the case. France or UK, for example, the money goes to another department. Have they actually recovered? That is a question that I haven't found the answer.
And this is a question that we haven't spoken about before, but it aligns closely with this, into the GDPR. Within the United States, many states are creating their own privacy bills and privacy laws. And one of the things that a small percentage of the states are putting in the bills is the idea of private right of action, meaning my data gets breached or stolen from company XYZ. In certain states, I have the ability to personally sue that company for not keeping my PII secure and for basically violating, in my case, the Colorado privacy law. Is there a private right of action for the GDPR in the EU?
Absolutely. There are actually three kind of sanctions. What the Data Protection Authority does is the administrative sanction. They can act based on an individual complaint, a group complaint, or they can self-decide to investigate a company. Sometimes it has been because the case came out on the press, and that attracts the Data Protection Authority's attention. Next to that, there is the Article 82 in the GDPR that allows a damage to individuals or a class action based on a non-material damage. It's more of a civil law principle. We sometimes call it the moral damage. But that so far I've been following that very closely. I personally think if I had my data breached, I should have a compensation. That for me worth more than what the DPA would fine, because I would like the companies to be more meaningful of keeping personal data safe. Especially with the pandemic, we've seen a very serious increase of security breaches. I see too many companies that are not doing what they should be doing to keep the data secure. And there is Article 32 GDPR requests that appropriate security measures be taken. The first part of the Article 32 mentions encryption, but there are other means. They refer to the state of the art. The French translation is the state of the knowledge. And that is put on balance. Everything in GDPR is put in balance. It's what we call the balance of proportionality. Depending on the level of sensibility of the data, the level of the finance of the data controller, what is available and the cost of what is available, security measures should be taken. I've specifically been fighting with some law firms, telling them you abide by confidentiality. The data you're holding on behalf of your client, or sometimes they are the opponent's data that you're dealing with, you ought to keep it secure. But they still send all documents by simple email attachment. And that today should be absolutely, totally banned. We should not anymore send anything by email. And the CNIL has actually produced documents saying you should not send sensitive documents by email. One is because it's hackable, although during the transmission of email is okay. But once the email is standing on the inbox, anyone could access it. And a lot of passwords are too weak. There should be systematically multiple factor authentication password. But it's very easy to make a human error. You're sending documents, you often start to type the email and it suggests you the full email. It happens. You wouldn't check properly if it's the right email or not. You send it to the wrong person. My home address is actually being on Google used by a private detective.
Oh, boy.
I have received mails from a law firm concerning a divorce to my address thinking I'm the private detective. Error happens. With email encryption, is extremely easy. The cost is nearly close to zero. So the balance of proportionality means systematically encrypted. That's even though the UK ICO has been one of the most, what I call dormant DPAs, they have recently fined actually a law firm for £100,000 because they had not encrypted their server. They hadn't done the appropriate update on their system. They were 5 months late, which to compare with many cases, 5 months is short time. But the UK ICO said, according to proportionality, according to what you had, according to what you should have done, you've been negligent. Therefore, they were fined 100,000 because they were attacked by ransomware that published a small part of the data on the internet.
Yeah, and I think we talked about this on a call, but we've reached a point with technology, and you just mentioned it, where PII at all times, but even especially when it's being set in transit and while at rest, should be encrypted. It's not, like you say, tough to do. The technology exists. It could be done very quickly, very cost effectively. And that's been my question. I've been doing podcasts with the United States senators and representatives, usually the co-authors of privacy bills and laws that have passed. And usually one of my first questions is, and they all have used almost exactly the same language across all the state bills. But the one thing that I centered on, and you just mentioned it here, it's not exactly the same words, but they all refer to PII must be, protected using appropriate security measures. And it's, well, what's appropriate? Or actually, United States, they don't use appropriate, they say reasonable. And I say, well, what does reasonable mean? Any first year new attorney can make the argument that what they did was reasonable. So I've asked them, why haven't you said all PII must be encrypted using at least a 128 or 256 or whatever, but it must remain encrypted at all times, at least in transit and while stored. And the senators don't know why. They don't have a real good explanation. And really that's the input they're getting from other state governments as well as industrial or companies in certain industries like cloud computing and that kind of stuff that are helping them write the bills. And they're being as kind of general as they can, so it's not locking people down. And three of the senators that I talked to, I said, you understand what I'm talking about now? And they said, oh, yeah. They said, over the next year or two, as we amend the new laws that we've put in place, they see trying to add the need for encryption, at least, of the PII.
Yeah. GDPR in principle is what we call technology neutral. However, in that case, Article 32(1)(a) explicitly requests pseudonymization and encryption of personal data.
That's 1A?
Yep.
Okay.
Article 32(1)(a).
By the way, I noticed in another part of the GDPR that they talk about encryption, and I think you and I actually discussed this on a call as well. And it was the idea that if there's a breach within a given company's system, then breach notification laws come into effect and you have to start notifying everybody, and it's a very costly process. And the GDPR, I think, makes reference that if the breached PII was actually encrypted and the encryption keys were not accessed, then in reality, the breach notification is not triggered because the data could not have been viewed.
Exactly. However, there are increasingly discussion about how actually a anonymization is anonymized, because with the evolution of technology, obviously, re-identification is becoming more and more feasible.
Yeah, with just a few number of personal attributes, right? I know there are companies, and I won't name them, but there are companies who can gather 5, 6, 10 personal attributes like a hair color, like your zip code, like your make of car, and basically determine who you specifically are by name and where you live down to like a 98, 99% accuracy rate. So controlling all of those attributes and making sure that those are protected as well is just as important, correct?
Yeah, this is an important element. If you are identifiable, even without giving your name, then it's personal data and should be protected. I've recently read a judgment. It was a French tax office fining an African citizen from Gabon, I think. His name was not appearing, but they were citing members of his family, his children, his wife, where they are based. He's got a mistress in Gabon, and they were giving the name of his companies and where they are located.
Wow.
Very easily, you put all that together and you know exactly who he is. And from him, you know who his children are. And that's become a problem. We are one between others calling for having open access to court decisions. France has open court decision recently with the highest Supreme Court and the administrative and the civil courts, with this condition that they would be anonymized. But they have thought about these things, that it's not simply taking the names off. Any other element that could put together and reveal the identity of person should be not appearing. And lawyers have asked that their name not to appear. because they think there would be revenge or whatever. I actually find it really good that the name of the lawyers in each parties would appear, because that's the best way actually to choose your lawyer. You know exactly which case they have worked on, and if they were good or not at it. Yeah, obviously they don't want to always to appear.
Lawyers are interesting people. A real basic question here, and I get asked it a lot. GDPR is effective worldwide, right? So if a company based in Colorado actually collects PII from their website or whatever from an EU citizen, then that company sitting in Colorado is subject to the GDPR requirements, correct?
Usually it was always with the US that we use the long arm of the US legislation. For once, is this. The GDPR has a long arm. Whoever target or deal and or trade with anyone based within the EU, no matter the citizenship of the person, it's more when you're based in the EU, then GDPR would apply. And the criteria is a personal data, which is slightly wider than what is in the US regulation with the PII. If I don't mistaken, PII doesn't include cookies, for example. Cookies are personal data. IP address are personal data. If you're based outside the EU, but you're targeting or aiming to have business with anyone based in the US, the criteria would be, for example, if you're using the currencies of any European country. Your e-commerce website in the US selling and delivering to the EU and selling by using any EU currency, then you're on the GDPR.
Oh, wow. I'd never realized that. That's really interesting.
The use of the language, the use of the currency and the targeting, the delivery, then you're on the GDPR.
Wow. Yeah, so it is far reaching. And by the way, the individual US state privacy bills and laws have the same kind of reaction. They're protecting data subjects in Colorado, Virginia, or whatever it happens to be. And if their data is being collected by a UK company, they're still subject to the attorney general within that state and that law. So this is one of the things that I've had conversations with others about, is the complexity that is basically rising with potentially over the next 3 or 4 years, 50 slightly different U.S. state privacy laws, a Canada privacy law, the EU GDPR, Australia's, China's, India's, and none of them are the same. So companies that deal with data subjects in all of those areas are going to have to find a way to figure out how that specific PII needs to be managed and reacted to if somebody asks about it.
Yeah. There's not a huge difference, but yes, you have wherever you target one specific geographic area, you need to check that you're compliant with them. But the Asia Pacific, people, however you pronounce it, in China has also been introduced. In US, you have a patchwork of regulations, so that's pretty much more complicated.
Well, yeah, and that's I've looked at the vast majority of them, and especially the bills that have passed into law. You have people who've glanced at them and said, yeah, they're all the same. They have basically the same rights and so forth. But if you get into the specific inclusions or exemptions within the Colorado law, or how they define certain things from state to state, they can be wildly different. In the New York law that hasn't passed yet, but I talked to the state senator on a podcast, and he's the only one who's done it so far, but he included the duty of loyalty and care in the bill, which is basically another way of saying that the data collector has to act as a data fiduciary. They have to treat the PII for the best interest of the data subject and not the best interest of the company itself. And I don't think that will pass anywhere, but it was a really interesting subject on that part. Staying with the GDPR, has there been any additional amendments or reforms to it in the last year or two?
No, there was a recent review, and thanks God they decided to keep it as it is.
Good. Yeah, I mean, it is the law, privacy law worldwide that everybody still is focused on because it was the first, but it's also prescriptive, it's relatively complex, and it's not just technology. I think the vast majority of it is processes and procedures by the actual humans handling the data, right?
A lot of it is based on the accountability principle, where you have to have done some thinking before acting to make sure that you are keeping data secure and you're not taking unnecessary risk around the data. There is the data protection impact assessment when they are higher risk. When you have a subcontractor or subprocessor, you have to sign specific Article 28 contract with them to show that you've made sure that they would respect the data the same way as they have to do. You have to keep some logs on what's going in and out. You've got what we call the ROPA for the bigger companies, where you need to keep an accountability of where data goes and what you're doing with that. A record of processing, it's called. So yeah, there are some formalities, but most of it is the 5 principle, which is keeping data secure, confidentiality of the data, data minimization. This is one of my favorite principles. Won't have more data than necessary. Well, you are safe from a lot of issues, including security problem. Limiting access to data, that's another principle that's important. Data accuracy is one that is often forgotten. It's part of the fact that you should not keep data longer than necessary. And if the data that you're holding is not accurate, you should delete it. You should not keep data that is inaccurate. I usually advise my clients to, on their privacy notice, to request the data subject to tell you about any change after their personal data. Otherwise, you're liable for holding a data that is not accurate.
Yes. One of the other things that I talk about a lot, and it's because of the GDPR and then all of these other global privacy laws that are coming into being, is I think it's forcing companies to manage all of their data versus just the records, the compliance records. And at least in the United States, only 5% of the data that flows through any corporation is actually regulated or compliant data that has specific retention policies. But it's the other 95% of the data that the companies don't track, don't even know exists, because it's sitting on individual laptops or it's up in cloud accounts, but it's all company related. And that data can hold personally identifiable information too. So when a data subject like me calls or sends a form in to Archive 360 and saying, what data do you have on me? If they're not managing all of their data, not just their records, then they can't give me an answer to that, right?
Yeah, absolutely. It's very important to have a data mapping. You have to be able to know where your data is held, where it goes, where it comes from, and where it's sitting.
And how it's secured and who has access to it. Because, if you're reacting to a data subject access request, you need to know, like you say, via data map, where that data is potentially and get access to it. Because they might ask you to delete it. They might ask for a right to be forgotten type of thing. And then you have to go find that data and delete it.
We also got under the GDPR data portability. So you go to one company and then you decide to change to go to another company. Company A has to be capable of providing portability of your data to company B. So they need to know where, in which box all the data is.
And that brings up another question, again, related, but nothing we've talked about. I don't believe we talked about it in the past, is the idea of backups. If I request Archive 360 to delete my data and they have to do it in 45 days or whatever it happens to be, what about those backups that contain my PII? Has there been a decision via the GDPR?
There's been a recent clarification by one of the DPA. I cannot remember who that was, because you have to prove that you actually received that delete request and you have done what was necessary. So the DPA has said that you could keep some backup as a proof that the request came and you deleted.
But if that PII that was deleted off of the active systems still remains on the backup tapes,
you should retrieve that backup and delete it.
Well, and that's the question, because I've read several opinions from European law firms and some in the US, and they've all said, and I think we'd acknowledge, that's extremely expensive, especially if you're getting 15, 100 deletion requests per month. You have to go find the individual tapes that may have my data on it, do separate restores, find the data, delete it, redo the backup, put the tape back, do the next one. And I've read opinions from especially European lawyers that say they think they could get away with not going to the backup tapes to specifically address a PII deletion request, but keeping a priority list. It says the next time that company accesses any of those tapes, then this list of data subjects need to be deleted. So there might be a month, 2 months, 6 months lag time, but the idea is that no one's accessing the backup tapes until they have to for a restore. And if they do the restore, then they're obligated to go find that PII and delete it. Does that make sense to you?
I have somewhere in my mind a case that actually said, no, it's your duty to go and retrieve the backup, but I cannot be 100% sure. Unless you prove that this backup is totally disconnected and hardly anyone got access to it.
So it's, in technical terms, it's air gapped.
Yeah.
Interesting. Yeah, I'd like to track that down because that's been a question I've been asking and discussing for ever since the GDPR actually became law. And I think it's a really interesting one that everybody I've talked to doesn't have an answer for. I think you're the first person who said, yeah, I think there was a decision on that. And that you can obviously determine that would be awfully costly. So if that actually is enforced, then you could see the whole backup industry having to change.
It all depends how you argue what you have to do or you're trying not to do. Going back to the balance of proportionality, if you could actually, on your accountability document, justify that retrieving this data would be costly, if the data is not accessed by anyone, so you can justify that it's just sleeping data and keeping doesn't make much difference. According to the sensitivity of the data, you can always document that and saying, well, we eventually, putting that into the balance of proportionality, decided that we will keep it until the next time we will access the data.
Yeah. But it's not a hard and fast rule that might differ from geography to geography, right? Ireland might look at it differently than Germany, for example.
Indeed. But they're usually sensible onto the reasoning that you're deploying. And if your company hasn't done anything else wrong, if it's just this, you get away with it. It's all dependent on case by case, on how you've justified it. That's very important.
Okay. And like you say, and you've said it a lot, and I think you need to, is the idea of proportionality is built into the GDPR. And that makes a lot of sense.
It's a lot of it is justifying why you have decided to do this and that. A little bit like, at the math test at school, if you simply give the answer to the calculation without explaining how you came to that result, it doesn't worth anything. What the teacher in the math wants, that you explain exactly the reasoning behind the operation.
Yeah, I mean, that's like the legal argument in at least the United States around e-discovery. And the plaintiff saying, I want you to check all your backup tapes for potentially responsive data. And the newer versions of the Federal Rules of Civil Procedure get into the idea of proportionality. And the judge could very well say, for this case, the cost of restoring 50 or 500 backup tapes doesn't justify it. So that's taken off the table and move on. And I think that really made sense. By the way, I read this last week, and I want just to see if you've heard about it. But I read I think it was a press release that basically said last week, EU lawmakers have made it clear that explicit permission is required from site visitors to install cookies on their computers. A visitor simply browsing through a website does not imply consent for their information to be captured.
Absolutely. The principle was based on a European Court of Justice decision, Planet 49. I believe it was 2018. That said there should be an explicit consent given by a positive act. And of course, there's a need of transparency. So there should be a privacy notice explaining who is accessing, and namely, not saying some of our colleagues would access it. No, it has to be every company that accesses this data should be named. And there should be an explicit button by saying yes. And recently, the French CNIL has fined Google and Facebook because the way of accepting and rejecting should be as easy. You know what I mean? There are a lot of websites, you would have the choice of saying yes, or how do they say that? Learn more, usually. It's this kind of expression. And then you go different steps until you can actually say, no, thank you, I don't want anything. Well, it has said clearly now, Google and Facebook have been fined. You should have two buttons, one accept and one reject. Can call something else, but it should be two exactly the same, not even two different colors. They should be two exactly same, and rejecting should be as easy as accepting the cookies.
Well, and that gets into the idea of dark patterns. Have you run across that?
The European Union has published actually a project on the dark patterns. I won't go further into that because I haven't yet completely analyzed the document. But yeah, this is on the radar.
Yeah, it's an interesting concept, and I've run across it. I've run across sites that do their best to fool you into giving consent, even to the point where you're saying, no, deny consent. Behind that button is, I accept. Even the state laws here in the United States now are starting to call out dark patterns to say, no, you can't do that. But I know we're getting short on time, and I wanted to ask you about the new development in the Privacy Shield that was invalidated, I think in 2020. It was the Max Schrems 2 decision, which I thought was really interesting. But just last week, I read on very many sites that said the EU and the US reached an agreement on a Privacy Shield replacement to enable transatlantic data flows. Have you gotten any more information on that? Is it actually a signed agreement, or is it an agreement in principle that still needs to be?
Principle. It's a political agreement between the European Commission and the US government, but it's not concrete yet. The reason why the Privacy Shield, that before was called
Safe Harbor,
thank you, they were invalidated is because EU citizens whose data is processed in the US and don't have a redress option.
Yeah, the US government, various agencies could demand access to that data, either via direct court request or via secrecy warrants, where you could go to a cloud provider and say, give me all of Bill's data. And if you encrypted it and you have the encryption keys, decrypt it and give it to us. And by the way, it's against the law for you to tell him that you gave it to us. And that freaked a lot of people out. And it's also the FISA laws, FISA 702. But I don't see how a new version of the Privacy Shield is going to get around those FISA laws and the Cloud Act and others in the United States, where it does give government agencies permission to access any data held by U.S. equipment or U.S. property.
They should. They can be a political agreement, but until FISA 702 and the Executive Order 1233 hasn't been amended, or a new executive order saying we are not continuing to do the same kind of investigation of European data, or initiating a right to redress for a European citizen, and having the ombudsman, as it was, the part of the agreement with the Privacy Shield was the US would create an ombudsman. That happened. So until all these are not done, it would be either Max Schrems is not happy with the agreement, so he would appeal again, and the European Court of Justice would say same. And within the EU, there are two different politics. One is the European Commission. They are the one who agreed with the Privacy Shield, but the European Parliament has a different position, and they've often been against the Privacy Shield. But yeah, until at the beginning, after the Schrems decision, a lot of US corporations came and say, well, we've got EU-based server. But that doesn't mean anything, because the FISA 702 allows the US government to intercept the data wherever the server would be.
If it's a U.S. server, right? That's the Microsoft Ireland case, right?
Yeah, Microsoft, Google, Facebook, they're all, even though the server would be based within the EU, some say that we will have our dedicated server in the EU. But that doesn't worth anything, because if the US government want to intercept, they will do whatever they want. Then for the Google Analytics, Google has said, we have never received a request from the US government. However, there are cases, they have published a list of their requests, but in some cases, they are not allowed to even reveal that we received the requests. And on the Google Analytics, I guess that they didn't ask access to the Google Analytics data, but wherever Google Analytics data is combined with other Google information, this is where they would go, and not the dispatched information on the analytics separately. So it's political. It's a shame because, yes, it does make the international trade very complicated. The problem exists with the US, but also with other countries. And with Russia, there's been recommendation of not sending any more data to Russia. China is another government that creates issue with unlawful access to data. I think it's fair game. As an EU citizen, I'm very proud to have a European Parliament that defend my rights and don't want to allow any foreign company to access my right. And obviously, US government has been complaining against the Chinese and the Chinese telecom that been banned because they were accessing US.
Yeah, Huawei. Yeah, that's you can really get into some interesting stuff, and that whole idea of putting data in the cloud and then a government, in this case the US government, going to that third-party cloud provider and saying, give me the data. One of the ways around that is, number one, to encrypt your data before it goes in the cloud, but encrypt it on-prem and keep the keys on-prem, and then you can put them up in the cloud. And if a U.S. intelligence agency goes to the cloud provider and says, give me the data and decrypt it, sure, you could take the data, but it's going to be useless to you unless you come to us as the company who owns the data and go through a court proceeding to have us turn over the keys. That way, at least you get around the whole idea of secrecy warrants and stuff like that. And we've had a lot of large companies basically say that is we're moving to the cloud, but we're really afraid to put a lot of sensitive data in the cloud because then it could be hacked by other nation states, by agencies, by hackers, and that kind of stuff. So if you're automatically encrypting the data, but you're keeping the encryption keys local, then at least you're slowing down the progression of that data being taken. And I think, and I've talked to European law firms about this, the idea of using encryption to send the data maybe to a cloud tenancy that my company owns and keeping it encrypted gets by the GDPR or the Privacy Shield or the old Privacy Shield requirements because the data is not usable. But if that data is encrypted in a way where it can be used while encrypted, you get into some really interesting, and I won't get into the technology, but it's called homomorphic encryption. But that is one way potentially to address this idea of EU data transfers to the United States, is putting all the additional technology around it so that at least, and you can include these specific technology requirements in the standard contractual clauses, and at least it slows down the data being taken. But that's a really complex question.
Yeah, it was part of what the European Commission, Court of Justice said on the Schrems II decision, that you should take appropriate supplementary measures. And part of the supplementary measures were encryption. Encryption is a very interesting subject. I'm all for it. However, government are also fighting encryption because then they can't access the data.
Or they want backdoors built into the applications. Yeah,
that's a problem. And yes, you can encrypt, send the data anywhere that doesn't have an adequacy decision with the European Commission, and keep the key in Europe. But when they need to work on the data, obviously they need the key. It could work if the cloud provider who is doing the transfer does not the key, then it arrives outside the EU, and then you communicate the key. So the company that would not be one of the internet communication services to whom US government can request access, then they will have the key and not the cloud provider. That's one option. But we've got the case in France with the medical health data that's been treated by Microsoft with DataHub. CNIL, the French Data Protection Authority, was asked to give their advice, and their advice was that because there is no other solution and temporary, they allowed that to happen in a short term. And they asked actually Microsoft to bring addendum to their contract to make sure that the data was processed properly. The temporary measures should end soon, and I don't think they have actually found a way to get around that. It's a shame that Europe has lost their digital sovereignty. We don't have really European cloud, and that's the big problem. There is a project, Gaia X. OVH is one of the partners. Unfortunately, OVH signed an agreement with Google. So it's kind of bringing the fox into the things of it. It's a shame. It's all lost its meaning. But there is a lot of conversation and discussion around having European cloud and Europe getting back their sovereignty.
Yeah, I think that'll eventually happen. It has to happen. But this whole idea of data privacy and how it's expanding worldwide is just adding a tremendous amount of complexity and cost to companies who, for whatever reason, collect PII. I mean, you have a company with a website, you write a white paper, you put up a form that says, well, if you want this important white paper, give us your name and your email address and some other information, you can have it for free. And then what do you do with that data? I mean, most companies will use it for direct marketing. Hey, we have a new newsletter, or we just came out with a new revision. But I think the biggest problem is other companies will collect that stuff and sell it, consolidate it, and do all kinds of weird analytics on it that lets them mine all kinds of information that the original data subject probably wouldn't like to have happen, but they don't know this stuff. So it's just it's going to get more complex. It's getting much more complex in the United States as well. But I think the EU was the trailblazer here in really coming up with GDPR. Do you think the GDPR is going to continue, probably relatively slowly, be amended over time to add new capabilities or new restrictions?
I've been with the GDPR since the reform. I was actually advising on the reform of the previous directive. In my opinion, what GDPR is missing is going after the data broker industry. That's probably something that should be added eventually along the line. Control and transparency is good for data subject, but quite often data subject don't actually realize what's behind. People say, oh yes, targeted marketing, I am therefore offered whatever I want and not something I don't want. It's actually much more than that. The whole industry in the backside is doing far more than simply telling you what you want. We've seen with the Cambridge Analytica, the way that political opinions have been manipulated, the way that we are all profiled. I was discussing today, Twitter has started to send me much more based on your likes, based on your whatever. They actually control what I'm reading. I'm not reading everything that all my contacts are posting. I'm reading what Twitter thinks that I should be reading.
What they're elevating is to what you're going to see first.
Yeah. But I'm thinking based on what they are saying that I like, I'm very interested to know actually in which category I am, because it looks like I'm very much into data protection and human rights and all these things. But if you gave my profile to a repressive regime, or if I was in China or Russia, I might go straight into jail. Why should I be profiled? Why should I have? We've let social media platforms take over a lot of power.
No, I absolutely agree. I think social media and
it comes to the point that
data brokers.
The president of the United States, you like it or you don't like it, but Donald Trump was the president of the United States. Who is Twitter to ban Donald Trump?
Exactly. I mean, you might very much dislike the guy, but there are millions of people on Twitter and even on LinkedIn that you dislike, and they're not being disappeared. That's too much power.
They let Donald Trump speak and tweet and send fake news and everything for years. Why then suddenly one day they decided that he should be banned without proper judgment? We are in democracy.
Or why should you be banned? I mean, if it's a free and open platform, then people should be intelligent enough to discount the garbage and everything, because to a certain group of people, it might not be garbage. To the other people, it might be. Basically, the social sites take a side by deciding which one they're going to delete. That's scary. That's very scary. So, Tara, I know we've used up almost an entire hour here, and it was a lot of fun. I really enjoyed it.
My pleasure.
For our listeners here, we're going to end the Information Management 360 podcast. I really want to thank Tara for this really enjoyable and educational discussion today on a very important subject of data privacy and regulatory environment in the EU, and like we talked about the US. If anybody has any questions on this topic or would like to talk to a subject matter expert, please send an email mentioning this specific podcast to info, I-N-F-O, at archive360.com, and we'll get right back to you as soon as possible. You can also email me directly at bill.tolson, T-O-L-S-O-N, at archive360.com. And you can also contact Tara to speak with her or to converse with her. Her email address, Tara's email address, is DATARAINBOW at DATARAINBOW, all one word, .uk. And also check back on the Archive 360 resources page for new podcasts with leading industry experts like Tara and legislators. In fact, I'm recording a podcast next week with the co-author of the Utah Consumer Privacy Act, Utah State Senator Cullimore, to talk about his experiences around the Privacy Act, specifically in Utah. So look for that. And I have several others on the resource page with other state senators. But again, Tara, I really want to thank you for taking the time. It was fantastic information. I learned a lot, and thank you.
My great pleasure. Thank you very much, Bill.
Thank you for joining us today on the Information Management 360 podcast, brought to you by Archive 360, trusted by organizations worldwide to manage their data in their cloud under their control. To subscribe to our show or to find out how you can address today's challenges in information management, visit archive360.com/podcasts.